This is case 29608 in re CR, CM, and CM. We are here for the oral argument. Each party will have 15 minutes to present its argument. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve rebuttal time, let me know. I'll do my best to keep you apprised of your time because I will be keeping track of the time. The arguments are being visually and audibly recorded to be posted online. Do not use the names of children. I know you both know that. Instead, please refer to any children by the initials or child or however else you wish to refer. We've read your briefs. We are ready to proceed when you are. Mr. Whitaker, you will go first and just let me know what you want to do about rebuttal.
I will. Thank you, Your Honors, and may it please the court, I would like to reserve 5 minutes for rebuttal. And so I represent the appellant mother of CM, and I would like to begin by saying there is really one important issue that I want to address in this oral argument that I think is the most important issue, and that is whether the medical opinion was a competent and proper opinion. In other words, whether it had any evidentiary value whatsoever. Everybody agrees that the central issue in this case is whether the child put his hands voluntarily under the water and was free to remove them, or whether they were held under the water. And the finding of abuse rests upon the fact that both the magistrate and the trial court and the judge in the journal entry accepted the opinion of Dr. McPherson that the hands had to be held under the water in order to get those burns as quickly as they would have had to have been gotten had his hands not been held. So looking at my opening where I phrased it, that the hands were not free to move, because if they had been free to move, then he would have yanked them out quicker. He would have yanked them out before they were burned. And that holds true if the temperature were at 125 degrees, but the temperature wasn't at 125 degrees. And so then the question is, what evidence is there that the hands weren't held free? The only evidence that supports the thing of it is that the notion that that those burns could not have occurred in the time it took for him to pull his hands out from underneath the water. And the fact of the matter is, though, that there was credible, uncontradicted testimony that those burns could be caused in less than a second if the temperature was above 140 degrees. So we have to look at the opinion of about whether it's abuse, and that's the point that I want to get at. The only opinion that this was abuse came from Dr. McPherson. And Dr. McPherson used an incorrect expression, and that is, when he was asked, can you say to a reasonable degree of medical probability, was this an abusive injury? He said, and I quote, what I can say is that it is consistent with an abusive injury. And this is a phrase that Dr. McPherson has used on a number of occasions. He says it's consistent with or concerning for abuse. That is not competent evidence. He has to be able to say that the injury is more than consistent with and competent with. And we have another case pending in this court right now that I mentioned in my briefs, in which the exact same phrase was used. He was asked, can you say to a reasonable degree of medical certainty? And he says, what I can say, it's consistent with and concerning for abuse. Now, this is not, a lot of times when you get into what's the proper phrasing of asking for an opinion, well, there's a tendency to say it doesn't have to meet any particular niceties. If it's clear what he's saying, then we're not going to hold it necessarily to use it in the exact words. But this goes to the very concept of that issue. And the concept of that issue is that there has to be a probability. We're talking about probabilities here. In order for an expert to give an opinion, there has to be probabilities. And so he has to answer in terms of the probability. Whatever words he uses, he ultimately has to say it's more probable than not that this is an abusive injury. And in this case, he doesn't say that. And same thing with the case that I mentioned earlier that I've cited in my brief that is still pending in your court. Because he goes to the heart of it, and he changes the question to say, I can say it's consistent with. Now, here's an example of why that isn't sufficient. And Dr. McPherson, also in his testimony, talks about you have to be able to rule out other causes. And then he diagnoses these opinions in terms of ruling out other causes. Because otherwise, and here's my example, somebody can come to the hospital with chest pains, and they can say, oh, God, I've got chest pains. I'm worried that something serious is wrong. Doctor does an examination, checks everything he needs to do, blood tests, whatever it is, and he may come to the conclusion that it's gas. And everybody's relieved, and that person goes home. And that is, he says, and the reason they do that is chest pain, gas can cause chest pain. So it's consistent with a heart condition that you would have those chest pains. It's also consistent with gas and some other problems as well that can cause the chest pains. They have to rule out that it isn't that before they start, send you to surgery or send you to all the variety of things that might need to be done if indeed it was a heart problem. So this is not a technical nicety. This goes to the concept of you must be able, in order to do an opinion, to a reasonable degree of medical probability. And so he didn't do that. And it's not just a mistake in his phrasing, because he's very careful about that phrasing, as he was in both cases. What I can say, my answer is that it is consistent with abuse. That doesn't raise abuse. The second issue is that the predicate here. He says this in his opinion. He says this in a number of pages in the transcript that he made this diagnosis based on a belief that the temperature of the water was 125 degrees. Now, by the way, you may have noticed I'm getting right to the heart of the issue. I haven't talked about what the facts are, but I think that usually if the court has any questions about the facts, I'd be glad to answer them. But usually I count on the courts, and you have told me that you have read the facts, and so that's why I'm going right to the issue. But the temperature, the only way they got a temperature of 125 degrees, which was the predicate upon which Dr. McPherson made his testimony, is that some workers from AMHA came to the apartment where the burn occurred the next day and with a meat thermometer and tested the meat thermometer in water that came from a different spigot of where the hands were. And they came up with 125 degrees. Even the magistrate was very skeptical of that. And you'll see in his statements, this wasn't very, I'm troubled by that. It wasn't very scientific. I was very surprised by it, and this is when we were going to introduce somebody else who went back out and did a series of tests from the proper places. And that's when the magistrate said, yeah, I was real surprised by that testimony too. It wasn't reliable. It wasn't credible. You couldn't rely on it. And these temperatures were all above 140. And at 140 degrees, those burns will occur in less than a second. So they can get those burns even if they're free to move it out. And as you know from the facts, the mother's testimony was that she had wiped his butt. He had gone to the bathroom. She said, wash your hands, went downstairs to grab some stuff out of the laundry. And when she heard the scream and came back up, once she got back up, she immersed his hands in cold water, which was hurting him as well. But nonetheless, he was free to move him out, and they showed that. Dr. Girton, who testified that you can get these second-degree burns in less than a second at 140-degree temperature above, and there's evidence in this case, if you look at the testimony of the gentleman that, the investigator that went out and used a thermometer, much more sensitive thermometer, and did it at various readings and did it from the spigot where the injury occurred, it could get as high as 100 and up in the 150s. Even Dr. McPherson in his testimony says, and I can cite the court to the page if you want me to, says that at 160 it can happen in less than a second. And so there's not a disagreement that it can happen in less than a second. The disagreement is apparently what the temperature actually was. In the only credible testimony, the 125 just wasn't credible. The only credible testimony was higher degrees. Even when the father went down and checked the temperature the next day, it was at 159 degrees. So, so at any rate, those are the important facts underlying the fact that Dr. McPherson was correct. He couldn't say to a reasonable degree of medical probability this was abuse. In actuality, it was consistent with. So in actuality, Dr. Girton and Dr. McPherson agree on that. And that is that you cannot say to a reasonable degree of medical certainty that these injuries were abusive. You can say that they are consistent with putting your hands under water at a certain temperature, if that's the case that it was that temperature, or consistent with not being able to freely move them out. Either one is possible. And in order to establish that these were abusive injuries, it would have had to be determined that it was more probable than, first of all, there would have had to been a clear understanding of what the temperature was, and then somebody would be able to say it is more probable than not, to a reasonable degree of medical probability, that this is an abusive injury. I don't know where I'm at in my time, but.
And I really apologize. I forgot to tell you when you were at 5 minutes, but you got 3.5 minutes left. You're fine.
Okay, that's fine. Then I'll wait for rebuttal.
Okay. Trinity DiMartino.
May it please the court, Heaven DiMartino on behalf of the Pelley Summit County Children's Services. We are asking that this court affirm the trial court's decision finding that the child was abused and that the siblings were dependent, based on the finding that the injuries in this case were non-accidental. Getting into the heart of the argument that's presented with regard to Dr. McPherson's testimony, it's important to note that the question that was posed to the doctor was, and based on your education and experience and within a reasonable degree of medical certainty, what diagnosis do you give or can you give with regard to the injuries for the child CM? And the answer was, in terms of CM, they are consistent with abusive partial thickness or second degree burns. So the answer that the doctor gave was predicated on the question, which was, is this based on a reasonable degree of medical certainty? The fact that the doctor didn't then use those 4 words in response does not negate the fact that the question he was answering was, is this diagnosis based on a reasonable degree of medical certainty? So this is not a situation where we're talking about, as Attorney Whitaker put it, niceties or the phrasing. It's clear from the context that the doctor was testifying with regard to a reasonable degree of medical certainty, even though in his answer he said consistent with abusive partial thickness or second degree burns. In addition, this doctor testified that when he made the diagnosis, it was not based on the temperature. However, once the testimony was presented with regard to the temperature of the water, the doctor said that did not change his diagnosis. So it's kind of a little bit, of a red herring and talking out of, both sides, I think, with regard to this issue of the thermometer, that it was a meat thermometer. There's nothing in the record to show that this meat thermometer could not accurately determine the temperature of the water. So I don't know why we're, really spending so much time talking about what type of thermometer it was when there's no evidence to refute the accuracy of the temperature. Beyond that, the doctor said that the temperature of the water that was testified by AMHA didn't affect the opinion, which was that it was consistent with abusive partial thickness or second-degree burns, in response to a question that asked, was it based on a reasonable degree of medical certainty? So the doctor's testimony is one of the factors that was presented, which the court found as facts, and there's nothing in the record to show that the court, erred in that finding. Certainly, there's enough evidence to show that this burn pattern was a child which would have a hand in a fist, which is an abnormal pattern for a child to be using when washing their hands. Also, in regard to the issue of whether that testimony was sufficient in Weissing versus DF Electronics cited by the appellant, the court went on to say that evidence is admissible even if it doesn't go to show the cause of the injury given by an expert, if it's not stated in the most accurate terms as far as probability, if it goes to refute the other side's claim of causation. And in this case, it would do that because mother's expert testified essentially that it's equally as likely that it was abuse as it was non-abuse. So that would refute the contention that this was an accidental injury. With that, the agency would rest on its brief unless there are any further questions with any of the arguments that were raised by Attorney Whitaker.
Okay, I see no questions. Mr. Whitaker?
Mr. Whitaker, we can't hear
Unmute,
you.
Mr. Whitaker.
There we go. Sorry.
There you go.
Yeah,
Okay.
there we go. I didn't mute it right away when I was done, and then forgot to unmute it when I started. But okay, anyway, I can't tell you how important I think this is. And Doctor, the question is, and it's very important because, as I say, this is not an accident of phrasing. This is a doctor that testifies in these cases all of the time. He knows what he's doing. He knows what he's saying. And he knows he can't just say. That's why he said in both cases, he changes the question in order to answer it. I can say it's consistent with. That isn't to say I can say to a reasonable degree, even though it was in the question. And if I find that question right here.
So I take it he wasn't examined more closely as to what he actually meant when he said what he said.
No, that's what he says. That's what he says in the past. It gets very confusing to delve into that any further because he's going to continue to use that phrase. And that's the phrase that he uses. Let's see. Oh, here it is. And based upon your education experience and within a reasonable degree of medical certainty, what diagnosis did you give or can you give the injuries of CM? In terms of CM, they are consistent with abusive partial thickness second-degree burns. That is not an accident of phrasing. That is what he says. And this is a question of, was there sufficient evidence for the agency to meet its burden proving by clear and convincing evidence? So he's making that statement, not in rebuttal of anything. That's what he's saying. That's the proof that there was an abusive injury here. When you look at the difficulties with the temperature, there's no possible reading. There's no possible way to say that it's clear and convincing evidence that the reading that the AMH workers did to come up with 125-degree temperature is a credible evidence. Certainly, especially when you see evidence, both what was seen the next day by the father and the significant testing that was done by another investigator. So, I'm sorry, go ahead, Judge.
You have me intrigued by this argument. So I have to reach back to some other scenarios. I'm thinking of totally different thing, but handwriting analysis case, where the expert doesn't testify and say, yes, that's the same handwriting. The expert says, yes, it's consistent with. I'm thinking of testimony in a rape case where the testimony isn't, yes, it's force. It's, yes, this testimony is consistent with force. You know, I see a torn hymen, I see this or that. And my thought always was that you use that terminology because you were not an eyewitness, but you're putting a different twist on it in terms of, I don't know what, proof? I mean, I guess I'm trying to understand more of what you're trying to say here. You're looking at it differently than I guess I used to look at it.
Right, and I'm saying it's the competence of the testimony. And frankly, in the example that you use, if that is challenged, and I don't know if they were challenged in the cases that you're talking about, because as we all might remember from law school, and I was told in a rather colorful way, you can do anything you want if it's not objected to.
Right.
I won't use the colorful expression, but nonetheless, if it's not challenged, you wouldn't. And if it's a minor part of the case, it doesn't become it. In this case, it is the only evidence of abuse. Otherwise, Dr. Girton's testimony is uncontradicted that, look, you just can't tell here. And by the
Let
way,
me ask you something.
Mhm.
What about the child's statement?
The child's statement, you know, the child, first of all, was a totally unreliable witness in this sense you know, when he was questioned back on the day. And that is, he said it was his hands were held under for 6 hours. You know, he didn't know his birthday. He didn't know his birthday. He didn't know how old he was. There were a variety of things that were, you know, it wasn't mom's fault. The bear held my hands under the water.
And remind me again, how old was he?
He was 5 at the time.
Okay, thank you.
And so he did say that. And keep in mind, his mother, immediately after he was screaming, held his hands under the water. And she did that, and it was painful. And if you looked at the test, with the testimony by both McPherson and Girton, they say it was put under the faucet, you know, and so he could have pulled it out. And nobody disagreed that the water running down the hands those were marks that showed the water was running off the hands. And Dr. Girton described that in his testimony very well. Visually, it was even better. He said, go to the bathroom here and go like that. The water's going to run down through your fingers, just like these marks here. So that's
one more question. So it's my understanding that mom's the one that turned the water on for the boy, and then she left the room, right? She didn't stay from to wash his hands. He was supposed to get up and wash his hands. But you're suggesting all she turned on was just the hot water? She never turned on any cold at all? It was just straight hot water, and she walked out of the room?
No. As a matter of fact, it was one of those faucets that go this way and that way to go hot or cold, and she just hit it up, which was right in the middle. Now, the kids were yelling and laughing and fooling around, and so it's one of those things that, and we don't know how they were fooling around, but obviously it got hit, you know, that little nozzle just got hit because it was hot when it hit the child's hands, which was several minutes after she had walked down to get the clothes out of the dryer.
This is the first I've heard that there were other people in the bathroom at the time.
There was another child in the bathroom.
Is there anything in the record that would say that?
I believe so. I believe that's what, you know, I didn't look at that because nobody's ever questioned that issue, but it was a younger baby, is my understanding. There was an older child, and that older child actually testified at trial, but the other one was not, you know, competent to testify. It was just a baby. But that, you know, that was fine with the CM playing with the baby. You know,
that child couldn't reach the handle, right?
I don't know whether the child, I don't know whether there was something to stand on or how they were fooling around, but there's no evidence that the child intentionally or even accidentally did that.
Okay. Thank you both for your arguments. We will take the matter under advisement, issue a written decision in due course. It'll be mailed to both sides as well as posted on our website and that of the Supreme Court. Thank you both very much. Have a great day.